I'm workers' compensation attorney William Underwood. I'm going to be talking to you today about a Form WC-240. Form WC-240 is a form used by employers and insurance companies in Georgia when they have a light-duty position that they want you to go back to work to do. It's used if you're currently out of work drawing temporary total disability benefits. The insurance company will provide a light-duty job description to your authorized treating physician. If you have an attorney in the case, they're also supposed to provide a description of the light-duty job to your attorney at the same time that it's provided to your authorized treating physician. The authorized treating physician will review the light-duty job description and decide whether or not you're able to do it based on your current diagnosis and physical exam. If the authorized treating physician signs off on the light-duty job description, then you will be served with a copy of that in the Form WC-240. In order for it to be valid, the insurance company has to provide you the Form WC-240 and the light-duty job description at least 10 days before they would like for you to report to the position in question. So they need to give you at least 10 days notice. The light-duty job description needs to be signed off on by your authorized treating physician, and also the authorized treating physician, the ATP, needs to have examined you within 60 days of the date that he or she signs off on the job description. So those are the different requirements that need to be met in order for the injured worker, in order for you to be able to be required to report to the job that they're offering, the light-duty job. Now the important thing is once you report for the job in question, you need to report, you need to at least attempt it for 1 work shift or 8 cumulative hours, whichever is greater. So if the shift in question is only 4 hours, you need to do 2 of those. Or if it's a 1 8-hour day, you would need to complete that. If you're not able to continue doing the light duty work, if you're not physically able to continue, you need to let a supervisor know, and you can go back out of work if it's within the first 15 days, and the insurance company has to immediately reinstate your temporary total disability benefits as long as you've done the job for at least 8 cumulative hours or an entire workday, whichever is longer. They have to reinstate your benefits. Now, if you refuse to show up for the light duty job, or if you don't complete 8 hours or an entire workday, they can request a hearing that you've unjustifiably refused to perform the job and seek to cut your benefits off. They can unilaterally suspend them. Now, if you attempt the job and you are not able to do it after doing an 8-hour shift or a work day, if it's longer than an 8-hour shift, if you're not able to do that and you have to go back out of work, the insurance company has to immediately reinstate your temporary total disability benefits. If they don't immediately reinstate your TTD benefits, then they lose the right to claim that the job was suitable. Now, normally they will immediately reinstate your TTD benefits. If they do that, they can request a hearing at that point to try to get reimbursed for the TTD that they have to pay from that time until the hearing. The burden will be on them to prove to an administrative law judge that the job that you refused to do was suitable and that you unjustifiably refused light duty. So there are different pitfalls and hoops you have to jump through when dealing with a WC-240. I hope that sheds some light on the process and what's required. If you get served with the WC-240, I recommend reaching out to legal counsel for a review to make sure it's been done properly. And good luck with your workers' comp claim.